Hi, this is Debbie Whitlock with Sound Financial Partners, and I am joined here today with my friend Stacey Romberg, attorney at law. We're answering all your pressing estate planning questions, and now I want to talk a little bit with Stacey about the non-traditional quote-unquote side of estate planning. For example, what if you have a couple that cohabitates, a man and a woman, and they've decided that being a married couple is not part of their life plan? How does proper estate planning affect them?
It affects them a great deal. And in particular, the first thing that I recommend for that couple, it depends upon their age here in Washington, because assuming that they are, again, a heterosexual couple, just like you stated, we do have domestic partnership registration here in Washington, but for heterosexual couples, that starts at age 62.
Wow.
And so prior to that, you can't register as a domestic partner with the Secretary of State's office, and you can't receive the benefits of community property and all the other tremendous benefits of our domestic partnership statutes. So based on that, really what I recommend for couples that are living together is the first step is that they go to separate counsel, which is required for validity, and execute a domestic partnership agreement that clearly states, because probably over time, a lot of the assets are being commingled, and it's really hard to tell who owns what, and it will help that couple if they split up to indicate how that would look, but it also helps for estate planning purposes. If one of them dies, you have to know what that person had to be able to probate their estate. And so it helps get that figured out. And it also promotes clarity within the relationship, financial clarity, which is very important. So once they go through that process, then really the second step is the couple needs to come in and get estate planning documents that are executed pursuant to their domestic partnership arrangement. And that would indicate, you don't want a situation where, your partner dies and say you both have been, living in a house, but it's one person's name. And it's always maybe their intent that when the one person dies, it goes to the other. But in reality, the law doesn't automatically work that way because they don't have the benefits of marriage. But with that, having both, the domestic partnership agreement and the estate planning to back it up, then that's what creates the legal pathway to make sure that their intentions are met.
Beautiful. What about this? A woman who is married but is contemplating divorce. How would estate planning work for her? What considerations would she need to make that might be slightly different than another couple?
That's always hard, because then the first consideration is, kind of a determination in terms of what's community versus what's separate property, which a lot of times married couples think, well, everything's community, but trust me, it's not that simple. And again, that was the law school class of, sitting there and taking the bar exam, and I have a textbook that's this thick in my office in terms of how to determine how that's made. So once you make that determination, it's really important for somebody who is fairly certain they're going to get divorced to go ahead and execute a new estate plan. Otherwise, what's going to happen is that if something happens to them in the interim period before the divorce is final, their ex-husband or their ex-wife is going to receive all of the community property involved in the marriage and some sort of percentage of the separate property, again, depending on the family structure involved and whether there are kids and et cetera, et cetera. And so you don't want that to happen. And also, as we've discussed before, the concept of the beneficiary designations. And a lot of times people forget that an estranged spouse is on their beneficiary designation form, so you find that life insurance and a variety of counts are being transferred over to them when that's really not what the deceased person would have wanted. So it does definitely take the bull by the horns. It's proactive. It indicates this is what my situation has changed. This is how I want things to be when I die, and it sets everything up.
What about someone who's single and they feel like they don't have a lot of stuff? They don't feel like maybe they don't own a home, or they don't have gazillions of dollars in their retirement accounts. Why is it so important for that person to make sure they have their proper estate plan in place?
I think that person needs to kind of think through the scenario of, okay, well, what would happen when they died? And starting with, how is anybody going to figure out what they have? I mean, their house isn't going to sit there forever with their dishwasher and all their bills piling up and everything. Somebody's going to have to come in and deal with their stuff. So who is that person going to be? And are you going to be responsible and step up and indicate how you want whatever stuff you do have to be distributed and who you want to take charge? Or are you just going to let it fly and not care and have your friends sit there, when they're already devastated and grieving over you and your family, and then try to figure out, what you would have wanted and who's going to take charge and really what's going on, because you haven't left the plan for them to follow.
Right. It really comes back to responsibility again, doesn't it?
It does.
Okay, perfect. Well, thank you again for joining us. You've been visiting with Stacey Romberg, attorney at law, answering all of our pressing estate planning questions. Thank you for joining us today.